Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined yet again by my co-host, Bro.
Oh, Alice, it feels like some sort of awful case of deja vu. I don't even know what to say about it, but I don't like it.
I don't like it either. Deja vu is exactly right. It feels like we just extensively covered Murdaugh 10 episodes, maybe more.
Extensively.
I mean, it was
Very
the last
extensively.
trimester of my pregnancy, and you guys, I'm not exaggerating when I say we finished recording the last episode and the sentence, was given, and I went to the hospital and had a baby. And today is my baby's 6-month birthday, meaning we are only 6 months removed, and we are here to discuss a motion for new trial that has been filed by Poot, Harpootlian, the defense counsel for Alec Murdaugh, after he'd been convicted of murdering his wife and son, Neri, 6 months ago. Brett, everybody wants to know how serious this motion for new trial is, what's contained in it, what are the legal standards, and we are going to give all of that to you today because there really is a lot to discuss. And I have to admit, Brett, when I first saw people posting and all the kind of news articles flashing across my screen that said motion for new trial, I dismissed it. I didn't click on any of the articles because a motion for new trial, as we have told all of you before on many episodes before, is filed in just about every case. It is filed in every case where there's a conviction. It's kind of like you take all your different shots. So I didn't even take the time to click on the article and didn't really look at the motion until enough people were asking questions that I thought, you know what, let me scan through this motion for new trial that surely can't contain much substance. Oh, I was a little bit wrong, Brett.
Yeah, I was too, because as you said, you hear about this all the time. They styled it as a motion, newly discovered evidence. And I thought, okay, we're going to have, somebody saw a 4-foot tall 12-year-old running across Moselle the night of the shooting, and that's going to be what they're going to say. And it's going to be silly, and we'll do the press thing, and some people will freak out on Twitter, and we'll all move on with their lives. But then when you see what it was, you realize just how serious this is. And it is serious. And I think that's the first thing that we should acknowledge. This is not about the show. This is not about getting Poot out in front of the cameras one more time for his next election to the South Carolina Senate. This is real. This is serious. And it implicates some very fundamental rights we have. And I think this is one of those times where we all have to step back, whatever we think about Alec Murdaugh, and recognize that the most basic guarantees we have are at stake here. Does not necessarily mean he should get a new trial. We're going to talk about the standard, but these are serious allegations. And look, whoever wrote this for Poot, because I'm sure he didn't write it himself, is a pretty good lawyer, and they do a good job on the first page laying out exactly what the allegation is. And so I'm just going to read you this paragraph, because if you've only seen stories in the news or if you've only heard things on Twitter, you may not know exactly what the allegation is here. So I'm going to read this to you. Specifically, during trial, the Colleton County Clerk of Court, Rebecca Hill, instructed jurors not to be, quote, misled by evidence presented in Mr. Murdaugh's defense. She told lawyers not to be, quote, fooled by Mr. Murdaugh's testimony in his own defense. Ms. Hill had frequent private conversations with a jury foreperson, a court-appointed substitution for the foreperson the jury elected for itself at the request of Ms. Hill. During the trial, Ms. Hill asked jurors for their opinions about Mr. Murdaugh's guilt or innocence. Ms. Hill invented a story about a Facebook post to remove a juror she believed might not vote guilty. Ms. Hill pressured the jurors to reach a quick verdict, telling them from the outset of the deliberations that it, quote, shouldn't take them long. Ms. Hill did these things to secure for herself a book deal and media appearances that would not happen in the event of a mistrial. Ms. Hill betrayed her oath of office for money and fame. And I'll just tell you, there are no more serious allegations that can be made against a court employee than those. I mean, these go, the oath that we all hold, those of us who are lawyers, those of us who work in the court, to do justice and to do it impartially is very important. And this really strikes at the heart of everything. And if it's true that she was doing those things to the jury, then not only might Murdaugh get a new trial, but she may very well, certainly will lose her job. And number two, should face criminal sanctions if these allegations are true. And we're going to walk through the evidence, the specific evidence of what's claimed here. And we're going to go through each of these allegations and tell you which ones are serious and which ones are kind of fluff. Because some of them are. I mean, some of these allegations are more fluff. They're not as serious, but some of them are very serious.
And kind of at the outset, Brett read you from the really first substantive paragraph of the motion. But what makes this motion, in addition to these very serious allegations, is that it's not just the motion. As you can see, if you've pulled up the document, there are exhibits, and these exhibits contain sworn affidavits, some of them sworn affidavits from jurors who are not named by name. They go by their jury number to give them some sort of I can't think of the word to keep them anonymous. Anonymity. Yeah. To give them anonymity, because obviously these filings are public, and as we've talked about, these filings should be public, and the public should know what is going on here. Some of these affidavits are by lawyers recounting conversations, but I want you to note that these are not just allegations with no backing up of them, and we'll talk about whether an attorney can go get these affidavits on their own, and what force they have within the court of law.
And let's just clear up a few things right from the beginning, because I know, as we often talk about, Alice and I understand intimately the way all this works, and a lot of you guys have no idea. This is a black box for you. The first thing I will say, the jurors are under no obligation to speak to defense attorneys. Often judges will say to the jurors as they're dismissing them, you're under no obligation to talk to either the prosecution or the defense. Either side may ask you to speak to them, because oftentimes lawyers like to hear from jurors. Like, what did you like? What did you not like? What worked? What didn't work? What was the strongest thing we did? What was a weakness? It can really help you going forward, particularly if you have hopes of maybe one day having another trial. In this case, I think initially probably a lot of jurors did not want to talk to the defense. A lot of them were adamant immediately after this, when speaking to the media, that they were 100% solid in their beliefs. But what we did not know at the time is, while all of this was underway, and by this, I mean the trial, the clerk of the court, Rebecca Hill, was writing a book. She was writing a book during the trial that she intended to publish when the trial was over. And the allegation in this book came out in early August. And when it came out, it really sort of crystallized things, I think, for the defense attorneys, and I think for some of the jurors who the defense attorneys ended up interviewing. The defense started going to these jurors, asking them about things they had read in the book, about whether or not there was undue influence by this person who was the clerk of the court. And over time, they were able to get some affidavits that we're going to talk about later. That's the thing about this kind of filing. You wouldn't know this the day after. This is something you'd have to suss out. There were things that happened during the trial that were a little quirky. You all remember the egg lady. She comes up in this, and how she was removed comes up in this. And it took some time for them to put this together. That's the first thing. The second thing, the jury, and one of the reasons this is such a troubling allegation, juries are 12, 14, including the alternates, maybe more. I think there were 5 alternates in this case. So 17 people. They come off the street. They're put on the jury. They don't know what they're doing. They don't know where to go. They don't know when lunch is. They don't know anything. There are members of the court staff who become very close to the jury. It can be the clerk of the court. It can be the courtroom deputy. It can be the bailiff. It can be some combination of these people. They get to know those people. Those people help them. They help them with all the things that don't have anything to do with the trial. They are never supposed to discuss the trial with them, but they can become very close to the jury. And the jury can see them as a friend and see them as a confidant. Someone who, if they have problems, can talk to the judge for them. The judge, ordinarily, is not doing that. The judge maintains some distance between himself and the jury, and you would expect that. So I think a lot of people are confused about why she would have this access, but it makes perfect sense. There is nothing unusual about her having this amount of access with the jury. What's unusual is that she would then use that access to attempt to influence them.
Absolutely. And to give you some idea of what her job would have been, kind of like Brett was saying, you show up every day and you're given directives from the court, and the judge is the judge, right? You all rise when the judge comes in, and they treat the judge with a lot of respect, but you don't want the judge talking to the jury, just like you don't want, because you don't want any undue influence there. You don't want things happening outside of the courtroom. Everything has to be on the record. So you have the clerk of the court in this instance, or you have, like Brett said, sometimes it's a judicial assistant, sometimes it's the bailiff, someone who is with the jury at all times to make sure, for example, that no one's harassing them, that no attorneys try to come up and speak to them when they shouldn't be doing so, to show them where the bathrooms are, because they can't just go wander off by themselves. There's even specific bathrooms that jurors have to go to make sure that they don't run into witnesses, to run into attorneys, to run into anyone who is part of the trial, so that they don't feel any sort of pressure, even if no words are spoken. To give you an example of how close these jurors can get to, like, their handlers in these situations, when I was clerking, we had an almost 2-month long trial. Very long trial. It was nothing, it was not a criminal trial. It was a civil trial. And the jury got very close to the judicial assistant who worked for my judge. And she was the person who kind of showed everyone where to park their car, where the refrigerator was to put their lunches if they were to bring their lunch or their eggs, to tell them, which restaurants they could all go to order food for them. They would all decide what food to order together, to kind of make small talk about the weather, because 2 months gets very long and you're stuck with the same 12 or 14 people. And they talk about their kids and, their likes and dislikes and their favorite shows and their favorite books. They became so close to the judicial assistant that on the last day of the trial, after the verdict, they had all made matching shirts. So the entire jury made matching shirts, and it had some phrase that the judge always said. I can't remember what it is, but it kind of bonded the group. And they made 12 shirts for the jurors and one for the judicial assistant, because she was essentially part of them in terms of how close they felt to her. And she did her job. In that instance, she only did really the administrative things. It's fine to talk to people about anything but the trial, but you can see just how intimately entrenched that person becomes. And those other 12 people, they don't really know what the duties of the clerk of the court are. So you can imagine, as these things are happening in the Murdaugh trial, they may not know that the clerk of the court is not supposed to be having one-on-one conversations with certain jurors in bathrooms, that she may not, that she's not supposed to be commenting on the testimony. These jurors probably have never served as jurors before. They are lay people. That is what the jury is made up of, lay people. They're not trained to be lawyers. They're not trained to be jury experts. That's the job of the court, to make sure they stay within their bounds.
And let me just say this. Jury tampering is one of the worst things that can happen in a trial. And so there's obviously been a lot of case law about this. We're going to talk about that in a little while. It's actually pretty confused because there's been so much. But one thing that's pretty fundamental, and one thing that I think most people agree on, is jury tampering is always bad. It's always bad when it's about the substance of the case. I mean, for instance, I'll give you an example of sort of a silly thing that we do in our cases. So when we get ready for a trial, when the jury is selected and the judge is giving his initial instructions to the jury, one of the things he'll tell them is, if you see the lawyers in the hall and they don't even look at you, they're not being rude. They're trying to avoid any perception that they might be trying to influence you in some way. So they're not even going to say hello to you. And there would be nothing wrong with saying hello to a juror or smiling at a juror or whatever, but you're trying to avoid any even hint of impropriety. If somebody off the street had stopped one of these jurors as they were walking into the court and said, that Alex Murdaugh, he's absolutely guilty, that would have been a problem. And it would have been something that would need to be talked about. And the judge would have needed to question the juror and can you put that aside? That's not going to affect you. The fact that a member of the court staff is accused of doing this makes this so much worse. It's just difficult to overstate how much worse it is that someone in that position is accused of being a part of this. It is so far beyond anything that you should see in any case. And the fact that she would do something like this, and look, I totally get it. Innocent until proven guilty, right? I mean, we don't know. All of this could be false, but it's not looking good. And we're about to go through the affidavits that the jury mentioned. And the way this is going to go, just to set it up for you, the first thing that's going to happen is a determination. So this is actually a motion to stay because there's an appeal in this case. So jurisdictionally, the trial court has lost jurisdiction of the case. They have found him guilty. They have sentenced him. He has gone off to prison. The trial court's out of it right now. The appeals court has jurisdiction over this case. So the first thing they have to do is actually file a motion to stay the appeal at the appeals court and return jurisdiction to the trial court. And then the trial court's going to have to decide whether or not to have an evidentiary hearing. And I think, based on what we've seen, that evidentiary hearing is going to happen.
With these allegations, I don't see how the court doesn't have an evidentiary hearing, but I think what you note here procedurally is really important. So when a case is happening, there are many courts it can be in, but only one court can essentially be a live play, right? And so the district court right now can't do anything because there's a pending appeal. And that is so there's not multiple contradicting actions within a case. One court has to talk to the other. And so once, and I think they will get the stay and it will be sent back to the district court. And once the district court gets it, then they can actually go into the substance of it. So that's really interesting. We've covered a lot of interesting developments in multiple true crime cases that are ongoing across the nation right now. And it's really interesting that we get all of the really meaty substantive motions in these pretty boring procedural motions, right? This is a boring motion in that it's just, hey, appellate court, can we stay what you're doing? Don't look at, the merits. The appellate court can't actually even look at the merits here in terms of determining whether there is any meat to the allegations. Of course, all of the affidavits and the allegations are included in order to show why the appellate court should stay the appeals and cede their jurisdiction to give it back to the district court for them to determine this. So you can see why there is so much substance within a procedural motion. But this is a very important point because we're going to see many more filings. And this court that received this motion can't do anything right now. And there's many more steps before we actually get to the meat of, did this happen?
And so I know a lot of you automatically and rightly don't trust Poot and Jim because, there's so much corruption down there anyway. And a lot of you guys don't like defense attorneys unless they're Bob Mata and you think they're all sleazy and they're probably making it up and all this other stuff. Number one, whatever the truth is here and whatever is eventually determined by the court, these lawyers are not filing a false motion. The allegations may end up not being true. They may end up not being substantiated. We may have an evidentiary hearing where the witnesses don't stand up, but they believe in this motion. And they have affidavits that they have gotten, which are testimony, sworn testimony under oath. And they are not faking this. They are not suborning perjury. They believe in this, whether it will be proven to be true or not.
Yeah, absolutely. And note, this is not cross-examined. We'll talk about, what actually happens in terms of testing whether this is true. But this is a very serious motion and it is backed up by evidence. So backed up by affidavits in this instance. Okay. With that all said, let's walk through the allegations. And there are several of them.
Yes. And if you've pulled the thing, they write a brief. It's a good brief. I quibble with some of their law, some of their interpretations of South Carolina law I don't actually buy. But the argument they make is pretty strong, and they follow it up with some pretty good evidence. And the first thing they do, and you often see this, good lawyers lead with their best stuff. And their best evidence is their first affidavit. And it's an affidavit of a juror number 630, who voted to convict in this case. It remained on the jury all the way through and voted to convict Alec Murdaugh. And here's what she says. I'm just going to read you some of the things she says from the affidavit. And I'll tell you what I think's a big deal and what I think's not a big deal. In a few minutes, once we get through sort of giving our views, we're going to get Bob on here and he can give you his. But big deal. Here's some big deal things that are in this sworn affidavit that if there's an evidentiary hearing, obviously this person, they're going to have to, they're going to have to get on a stand and repeat these things. But this is what they are alleging. Towards the end of trial, after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury not to be fooled by the evidence presented by Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also instructed the jury to watch him closely immediately before he testified, including look at his actions and look at his movements, which I understood to mean that he was guilty. Now, put aside her editorializing at the end about what she took that to mean, though that will be important. If those allegations are true by themselves, if she did that, those things, that in of itself is a huge problem and is potentially grounds for a new trial. She should not have done any of those things. They are incredibly prejudicial, particularly coming from her. And she would have known that this was not an accident. I think that's another important thing. If she did this, she would have known exactly what she was doing. And we're going to talk about more stuff. That alone, what we just told you, may be enough to get a new trial. And I'll just tell you, if you look at the case law, the cases that deal with this kind of stuff, it'll be things like a bailiff makes an offhand comment to the jury, and that ends up going all the way to the Supreme Court of South Carolina about whether that's enough to overturn a conviction. This is so much worse than a bailiff making some offhand comment.
Right. And the offhand comments are literally like that, a cough, like, oh gosh, as opposed to actually commenting on the strength or the veracity of Alec Murdaugh's testimony. And again, I think that is so key here. The affidavit doesn't just say what the juror number 630 thinks it meant, but there are quotations as to what this person remembered Rebecca Hill saying.
Now,
And
let me say some things. Oh, go ahead.
Remember when we were talking in our 10 episodes, the jury is not supposed to discuss with each other or anyone else any of the testimony, any of the evidence before the case is submitted to the jury for deliberation. That is incredibly important. We said that many times. So every time they take a break, they're supposed to go back and talk about anything but the case, or talk about nothing, but they cannot talk about the case even with each other. They certainly can't talk about it with the clerk of court. But here in another line of the affidavit from juror number 630, this person also says that after Alec Murdaugh testified, the foreperson, juror 826, said Mr. Murdaugh was crying on cue. If that is true, that isn't tampering there, but that is also a something that should not have happened within the jury, because we know that they can't talk to each other ahead of time. And if it's right after Mr. Murdaugh testified, then we know that's before closing and before the jury entered deliberation.
And I think, look, that by itself is not going to result in a new trial. You might file it, and it might be frowned upon, but the sort of no harm, no foul analysis of harmless error that eventually will happen would deal with that. But I think the reason they include it and the reason it's important is it goes to sort of the atmosphere in that jury room. And one of the things they say happened is that Hill would go, and there's stuff in the affidavits about this, that Hill would go into the bathroom with the foreperson and they would talk for 5 or 10 minutes. And then they would come out and not say anything to the jury. And so the fact that the foreperson is having these conversations and saying things about the case as it's going on, we don't yet know for certain. They will be questioned about this in any evidentiary hearing. But the fact that they're doing that, you tie those two things together, and what does it sound like is happening? It sounds like he is her agent. He is now helping to advance what she wants to happen. And the whole reason she's doing this, she's writing the book, and she knows if he's acquitted or if it's a hung jury, she doesn't have an end for the book. That it can't go that way. He needs to be convicted for her book to work. And remember, she is she used to be a court reporter. She got elected to clerk of the court in Colleton County. This is so much bigger than anything that ever happened in that county. Worldwide attention is on this case. And if this is true, then you can imagine what she was thinking. This was her chance to live her dream, to be on the Today Show, to be in these documentaries, to write a book that becomes a bestseller. And who knows what she might be able to turn that into. That is what's driving what's happening here.
Yeah, I mean, there's probably another case that has reached this level in the Colleton courthouse, or really any other case. Why did we spend 10 episodes talking about this trial that was, had everyone around the world on the edge of their seats? Because this was the stuff of movies. And here's the thing. The jurors, of course, they can talk to the media afterwards. No, there's no gag order on the jury after they have their verdict. But no one understands the law and the court and has access to the jurors who are the ones deliberating as Rebecca Hill. And so those of you who are wondering, why would she do this? For everyone situated within the courtroom, there's actually no one better to kind of have the tell all than her. The judge doesn't have that, nor do judges typically engage in, these books after the fact, but the judge isn't back there with the juries. The attorneys, they can tell their side of it, but they're not back there with the juries. They don't know what's going on. What's important and what's riveting about this case after the fact is what the cameras could not catch. And what the cameras could not catch is what happens behind closed doors. And who had access to those closed doors? Rebecca Hill. And so she is uniquely situated to profit off of this case. We're not supposed to, and that's why there are regulations and laws in every state, including South Carolina, that prevent court officials from using their position to profit. And that's because we need to be able to have positions within the courthouse that hold these important powers. And if people are doing this left and right, I mean, there is a lot of problems with our constitutional protections.
And I think that's so important. And like I said, I know a lot of people are going, and including me, are going to be inclined to say this is not a big deal. He's obviously guilty, et cetera, et cetera. But juries aren't kabuki theater. We don't do it just as like a show trial. We do it because they're supposed to be the ones making the decision without outside influence. The reason we have all of these rules of evidence, the reason we had multiple arguments outside the presence of the jury about what should come in, the reason we had multiple days of testimony the jury didn't even hear, just so the judge could decide what comes in and what doesn't, is because we believe that these cases are supposed to be decided on admissible evidence alone, not the opinion of the court clerk. And look, jurors are trying their very best to figure all this out. And they actually are pretty susceptible to this kind of stuff. When they're hearing somebody who they see as someone in a position of authority, someone who has worked in the court, someone that they trust, and they're telling them, look, you're a juror. This is your first trial. This is my 1,000th trial. That guy's a liar. You shouldn't trust him. That is going to have a huge effect on how they view the case.
And remember one other thing, the jury is instructed and they're not supposed to be listening or consuming any sort of news analysis on what's happening. They're not supposed to watch the news. They're not supposed to be on social media. They're not supposed to read anything about the case. And so think about it. Whenever you hear something, for example, this filing, what do you go do? The first thing you do is to see, is some podcaster doing some analysis of this? Is there some news article about this? What am I supposed to think about this? That's what we all do when we are faced with having to be a decision maker in an area that is not our expertise. We kind of look for people to help guide us. And so the jury members, they're not consuming news media. They're not listening to Bob Mata talking every day after the testimony, talking about, this person shouldn't have said this. They don't hear any of that. All they hear is what happens in the courtroom. And the courtroom itself is devoid of any reactions, as it should be, right? There's not a laugh track. There's not gasping. In fact, The judge had to admonish certain people in the gallery who were watching the trial who had too many facial expressions, right? Buster, for example. And the reason the judge did that is because you're not supposed to have any reaction in the courtroom that may shade how the testimony and the evidence is received by the jury. So think about this. We are so shaped in our lives and how we receive and analyze information based on people's reactions. Think about the classic example of a baby. You're holding them, and you'll see lots of like TikTok videos or you know uh, YouTube videos or whatever of someone knocking the wall and not hitting the baby's head, but pretending and reacting like the baby's head was hit, and they make a loud sound, and then the parent like goes, the baby immediately starts crying because they are receiving inputs from around them and reacting like they think they should. The parent holding me just freaked out, therefore something terrible must have happened, so I'm going to start crying. That's a baby who hasn't been, trained in this world to understand all the analysis of the world. It is just human nature to take in the reactions around you, especially of those who should know better. And in this instance, the jury is listening to cold, hard evidence, no reactions by anyone in the jury room, no laughing, no gasping, no analysis. They're not reading any sort of news media analysis after the fact. They are sequestered. They are not supposed to talk to anyone about this case. And here you have Rebecca Hill making a small comment that a juror may not at the time recognize is tampering with the jury. This is why her comments are so bad.
And, just to address quickly things I see in the chat. Number one, she's alone with them because that's her job. We trust the clerk of the court not to do these things. You don't have to have 3 or 4 people in there to make sure nobody's messing up. This is a small county. They don't have a huge staff anyway. We trust her to do this. This is her job. She takes an oath. There are criminal consequences for this if she did this. So, yeah, I mean, I get it. It's too bad that she was the only one in there, but that's the way it works. Number two, why did the jury not report it earlier? The jury didn't necessarily know any of this was improper. They see her all the time. They hear the judge saying, don't talk to anybody about the case, but they don't necessarily think that the clerk of the court is that person. They don't necessarily know until she writes a book and a defense attorney shows up on their door, and they may just, and they're like, yeah, I really didn't think you did it, but I was talking to Becky and she said this, and I thought, yeah, that's a good point. And the defense attorneys are like, what? What happened? They may not even understand. They don't know all the rules. So it's not necessarily surprising to me that it took a little while for the light bulb to go off for them, or at least some of them. Oh, this is problematic.
And remember, the reason, and we see this a lot, not just in juries, but in any sort of decision making, when you've rendered a verdict, the jury, of course, wants to stand by it, not because they're trying to cover up any malfeasance, but because we as people want to make sure that what we've done, which is sending a man to prison, was rooted in all the good things, right? All the constitutional protections were at play here. And of course, you want to defend your decisions, whatever they are in your life. And we see this with juries all the time. They don't want to talk to anyone about their verdict. It's not usually until sometime later or some new information like we have here with Rebecca Hill's new book that juries will start to say, well, I actually did feel pressure to change my decision. And I want to address something else because I know this conversation can go on for a very long time. A lot of people have said, okay, so this is really bad. What Rebecca Hill did was really bad. This looks like the newly discovered evidence was tampering. Who cares? Alec Murdaugh is so clearly guilty. He admitted to all these sorts of things on the stand. Whatever. We'll have a new trial and he will just be convicted again. Big deal. Here's why. This is a 6-week trial. There were incredible resources poured into this trial, not just money. It is years and, yeah, literally years of investigation and years of hard work and a lot of money to prep up this trial, not to mention 6 weeks of the court's time and all of the witnesses and everything that goes into having a 6-week trial. And we've talked about the jury being a black box. Not only is this a cost thing, this is not just oh, it's just money. It's just money. We just have to have another 6-week trial and it will render another guilty verdict. Now, everyone's had sworn testimony. The defense essentially has a playbook of what the prosecution's going to do, and they have sworn testimony to be able to cross-examine every nitpicky word that is slightly off the second time someone testifies. That is a huge deal because guess what? When you testify, when you speak under oath, when you speak in general, even when you are speaking the truth, it is almost impossible to verbatim say what you have previously testified to. And that's actually a marker for us when we're kind of interviewing witnesses of someone who's telling the truth. When their story changes ever so slightly the next time they tell it because they're not memorizing a script. But because of that, there are going to be a million things with every single witness that the defense can cross-examine them on and essentially make a sideshow with the jury as to whether each of these witnesses can be trusted. And that may play very differently with a new jury when now every single witness, instead of just having to think about whether you believe what they've testified about, there's this whole other trial happening of, well, last time they said it was 15 minutes. Now they're saying it's 12 minutes. 3 minutes is a long time. What can we trust about for anything? And that's not the only thing. They also said it was 5 feet. Last time it was 3 feet. What are they just trying to change their testimony now? This can have a very serious effect on uh, whether jurors put credibility or give credibility to certain witnesses. And times 6 weeks over, it it could very well play incredibly differently. And also, we know from this particular jury, some of them had questions about whether they should render a guilty verdict. So even if the evidence to us on the outside seems slam dunk, he's going to be convicted again, I think we have words from the jury in this very matter that they weren't completely sure. And you would expect that in any case, especially when it's as serious as sending a man to prison for the murder of his wife and son. So I just want to address that really quick because this is not as easy as let's flip the switch. Everyone take your roles again. Let's pull out the scripts. Let's go 6 weeks again. And we're just going to end up in the same place with a new jury. That's not exactly how it works.
Yeah, and I'll just point out a few things. Number one, finding a impartial jury at this point is going to be even harder. It's kind of like in the Casey Anthony case. You ended up with weirdos because everybody, the only people who'd never heard of the case were people who lived in caves or whatever, right? And some of the prosecution was like, yeah, we had this jury that basically, the only people on the jury are people who'd never heard of it, and who are those people? And so you're going to have a similar problem. It's a small county. It's going to be hard to find people who don't already have their minds made up. That's the first thing. The second thing, somebody said, yeah, but the defense will have the playbook too. No, completely different. The prosecution has the burden. The prosecution has to prove everything. The prosecution can't just change up its strategy next time. The defense can. The prosecution has to put this case on again with the exact same witnesses. In the press conference, you had Harpootlian say one of the SLED agents perjured themselves because he made a mistake at grand jury, which he admitted on the stand. But that's what he will do. And now it's not just going to be one SLED agent with grand jury testimony. It's going to be every single person who testified. The other thing, in this trial, Alec Murdaugh testified, he lied, and he got caught in it. And that was important evidence that could be used against him. This next trial, unless he's a complete moron, which he may be because he's so full of himself, he will not testify. And he will not set himself up for that. And the jury will not have that very powerful evidence of guilt that this jury had, and it very well could make a difference.
Absolutely.
So, look, I don't want to go through every single thing in here because we'll be here all night. To suffice it to say, there's a few things. There is another affidavit that is not by a juror, but by someone who spoke to a juror. It's a little weird. The affidavit basically says they couldn't get it set up for this person. Makes me question the affidavit. But in the affidavit, the person who interviewed her says, or him or her, whoever it is, that before the defense put on the case, Hill said, y'all are going to hear things that will throw you all off. Don't let this distract you or mislead you. The other affidavit is from Egg Lady, who you may recall was kicked off the jury, who had the eggs back in the room. A lot has been made of that. Actually, don't find that convincing at all for a couple reasons. Number one, it seems to me that the things that happened there could very easily just be confusion. For instance, they found a Facebook post by a person who has the same name as her ex-husband. That could have just been a mistake. And it wasn't just the Facebook post that got her kicked off. She had told other people that she had already made up her mind as well. So not a big deal. The
And I want
issue
to
is going to be these first two jurors and their affidavits.
and I think this is really important because it's kind of easy to seize on the egg lady thing and say, see, we got someone kicked off who was going to vote not guilty. I want to note that the reason I don't think it's going to be a big deal is whatever Rebecca Hill was doing, if she made up the Facebook post, if she questioned the juror without the court there, note that the juror in her affidavit said to the judge after she was excused, is this because I talked to Rebecca Hill? And the judge said no. So I don't think what Rebecca Hill did, if it's true, is still terrible. But I think there were independent reasons, and we've talked all the time about harm. Like, what's the harm? If there were other reasons for her to be excused other than what Rebecca was trying to do, then there's kind of the no harm, no new trial sort of situation. But the other jurors' allegations of what Rebecca Hill said, that is harm. A lot of
Yeah,
harm.
absolutely. And there's going to be so many interesting legal questions in this next trial if it happens. But okay, so before we put Bob on, because I want to hear Bob's views on this right after I pick, I think the Bengals defense is what I'm going to go for. Bengals
Okay,
over
while
the
you do that, let me
Commanders.
just tell
We'll
people the
do that.
legal standard in case we've said
That's
this
what I was
a
going to
lot
say.
of
We're doing the
times.
legal standard.
Okay, let's do the legal standard while you pick whoever it is. I'll carry the water here, Brett, while you make sure you have the right team. So the standard here, and there's always a legal standard section in the motion. You can go read it. I think they kind of take some liberties with it, and they maybe go a bridge too far. But with that all said, a motion for a new trial based on after discovered evidence. And the reason it has to be after discovered evidence is typically you have to file a motion for a new trial within 10 days in South Carolina. That's pretty typical. There's a short amount of time because there's been all these resources that have been expended, and basically you want to get to the next court. You want to get to the appeals court, which is where the case currently is now. But obviously, if you have newly discovered evidence, you can't have perhaps found it within the 10 days. So South Carolina says you have to file a motion for new trial based on newly discovered evidence within a year of finding out the new evidence. We are well within that time frame because the book came out, I think, August 1st, something like that. This motion was filed basically within a month of that. That is actually pretty fast. By the way, this is why I kind of have some questions about the affidavits with regard to the attorneys who said what they heard from a juror as opposed to the jurors themselves. They weren't up against some sort of statute of limitations or the year mark. And so I can imagine if they were on day 364, they had to get this motion on file, but maybe that juror was out of the country, sick in the hospital, whatever. They literally couldn't get to the juror in order to have the juror swear to the affidavit and sign it. I can understand in that situation why someone else who heard what the juror said signs the affidavit. In this case, we still have many months. Of course, these are very serious allegations, and they want to make sure to get it on file while maybe the public media is still interested in the Murdaugh case. But I am a little wary of the affidavits that are not signed by the actual jurors themselves, because we know that South Carolina allows this motion for a new trial within a year of the discovered evidence. Now, I would say a lot still needs to be discovered, as we can tell based on the allegations here.
And so they're going to have an evidentiary hearing. I have no doubt about that. And maybe all these people will come in and they'll say, no, she didn't say any of that. That's ridiculous. Maybe the juror will say, well, I didn't hear her say that, but I heard somebody else say something that I thought was her saying that. And so I put it in the affidavit because I thought that's what she said. There's no telling what will happen. As we've talked about in other cases, affidavits are great because they're not cross-examined. And you're not sitting in the witness chair having to say in front of judge, God, and the entire media from around the world exactly what happened. It's possible they have an evidentiary hearing and they just find these allegations aren't credible. And since they're not credible, no new trial, we move on. But let's assume for a second that they are credible. It did happen. Assume that for a second. Assume the worst case, that Hill was attempting to make this happen. There are a few cases that govern this. There's a Supreme Court case called Rimmer versus United States. It is from 1954, and it's supposed to set the standard for how this is handled. There is so much ink that has been spilled on how no one really knows how to deal with Rimmer and how to apply it. And so every state and every district has a different rule. In South Carolina, there's also some confusion. And if you read the brief, you know this. The defense really grabs on and hugs tight this 1993 appeals court decision. And there's a reason for it, because it says something that, if this is the rule, means Alec Murdaugh's going to have a new trial. And I'll just read what it says. So in this case, it says, when there was private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial must be granted, unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. That is as high a standard as you could possibly have. That is essentially a structural error standard, that if there was a communication with a court official and it was about the trial, new trial. I mean, that's essentially what it says. And certainly her communications under that standard would result in a new trial. So if that's the standard and the court finds that she said these things to the jury, there's going to be a new trial. Now, that was 1993, and that's a very broad statement. In 2020, there was a South Carolina Supreme Court case called State versus Green. And it's funny, as I said earlier, these all deal with bailiffs, and this one dealt with a bailiff as well, who said something to the jury. And they don't seem to have that high a standard. And they go back to this Rimmer case and basically say it's Rimmer that's going to govern. And if Rimmer governs, which is the United States Supreme Court, so you think it would, the way it would work is this. If she had that conversation with these jurors, then you would go to the presumption. There will be a presumption that there is prejudice and we have to have a new trial. But it is a rebuttable presumption, but it is one that is heavy. And this is what they say. The presumption is not conclusive, but the burden rests heavily upon the government to establish that such contact with the juror was harmless to the defendant. So basically, if she did this, what you would need is every one of those jurors to essentially say, yeah, she said that, but I didn't listen to her. It didn't matter. There was so much evidence. It was huge. Obviously, was guilty. Doesn't seem like that's what they would say based on the affidavits of these two jurors, but you never know. And that's going to be part of this evidentiary hearing. There's going to be two parts of it. Did she do it? And if she did it, can the government prove that there was so much evidence against him and the jury really just considered that evidence and was able to put what she said out of their mind? Is there enough of that to maintain the conviction? I think that's going to be a really, really difficult thing for the government to do, given the number of communications, the explicit nature of these communications. It's going to be tough. It's going to be tough if it turns out that these things are true.
Whew. So with all of that said, the allegations are serious. I do think an evidentiary hearing will happen here, but there's a lot. That evidentiary hearing will be big, and it will probably be very long. And like Brett said, I can't emphasize this enough. Even though there are affidavits in this case, they are untested. There's no cross-examination. They're not even under questioning. They were written by somebody else. Even though the person signs it, these affidavits, just so you know, are probably written by the attorneys. There's nothing wrong about that. It's because the attorneys want to make sure they get the right words, and they work with the witness typically. Are you sure this is what they said? But it's going to be the words of the attorney. It's very different when someone takes the stand and has to articulate without an attorney putting words in their mouth, as an attorney is doing when they write an affidavit for someone. So it's very possible that a lot of this falls apart when someone's on the stand. It doesn't mean that these affidavits here are fabricated. It's just that people tend to be less specific until tested under oath. with cross-examination. So I just want to note that this is very serious, and if true, it is serious. But hold kind of judgment until we hear what happens at what I think will be an evidentiary hearing. And welcome, Bob Mott.
Welcome, Bob. And before Bob starts talking, I just want to say one more thing. There are just certain things I want everyone to understand. Number one, this is not some made up thing by the lawyers. No matter how much you hate them, they didn't just make this up. Number two, this is not some plan by the Murdaughs and this woman to, if he loses, be able to undermine the conviction. That's not what happened. There's no conspiracy here. This is pure selfishness if she did it. And number two, the evidentiary, we are at very early stages. These are serious allegations, but the evidentiary hearing will be huge.
Yeah, really quick, I want to debunk that because I think that's not debunk what you said, but debunk any sort of conspiracy theory that the Murdaughs had their hand in the Colleton courthouse for this specific matter. If the plan were for the Murdaughs to somehow get Rebecca Hill on board to tamper with the jury so that later on they could ask for a new trial and maybe end up in federal court, he would not have taken the stand because he said a lot of things that will make him go to federal court forever. And so if the plan was to be able to overturn a murder conviction because the evidence just looked so bad for him, then the plan would have been Alec Murdaugh does not take the stand, because when he takes the stand, he incriminates himself in so many, many federal crimes and other state crimes that would be a terrible conspiracy. So I think that is very important here. I think this is about one person's, if true, one person's greed and not some massive conspiracy across South Carolina. And look how powerful the Murdaughs are. So don't fall into that trap, because I do think it's a trap. And look, we're always welcome to new information that may change our minds, but I don't think that's what's at play here.
And with that, welcome Bob Murdaugh and Scarlett to the show.
Hi.
Hey guys.
Hey guys.
Hi. So she wanted to say hi to her two favorite prosecutors.
Hi. It's so good to see you.
It's so good to see you. I love your pigtails.
Yeah,
braids.
She did this all herself because Mom is in Vegas for a birthday.
Oh.
So
also, my mom doesn't know how to do French fries.
But you do.
Also, my dad doesn't want me to be a lawyer.
Yeah, I really don't.
Good advice from your dad.
Why do I want her to
be a podcaster instead?
Exactly. Way more fun. So, hi guys, I'm super excited to see you guys in a couple weeks. By the way.
Oh, I can't wait. I was, this woman's ruining my steak dinner. Bob owed me a steak dinner.
I'm good on that bet, dude.
It sounds like the whole thing is flawed. I think the bet's off.
I don't know, man. Like I lost it fair and square. I mean, we could.
Did you? I don't know if you did.
I don't know. I guess I'm good for it though. You know what I mean? We're gonna have the steak dinner regardless, and then if it shakes out at the end of the day after an evidentiary hearing, we'll figure it out after that. But
have you ever seen anything like this, Bob?
Man, no. Like when that thing came down, and it's like you wake up, you hear that they're having a presser. Immediately you're thinking, all right, what is it? It's going to be some BS. And then like I took a nap because I had to get up at like 5:45 to get Allison to the airport. I came back home, got the kids off to school, drove Scout, so I fell asleep for like 3 hours. And I wake up and there had already been a press release before the presser. So and they had released the document. So like, I didn't really have a chance to dig into it, but I started to look at kind of what the basis was, man. And I was like, wow, this is legitimately, and like, it matters not which side of the aisle you're on when it comes to this. It's sacrosanct in terms of what's important to us as attorneys. I mean, the jury process cannot be attacked like that, and it's like, Brett, you guys both nailed it in terms of it's who it was is what makes it so damning. It's such a breach of her duty as an elected official. If it's true, that it sets you back, man. It like really stunned me. So then obviously I had to dig in. You're reading the affidavits. I agree with Dallas. I think they may have taken some liberties with their standards in terms of their argument, and it wasn't really well fleshed out. I think they're relying on the fact that the affidavits are pretty powerful, that they didn't really have to lean into the legal argument quite as much. But Man, yeah, it was something like it's like the case that'll never die. I mean, it like just when I
Unfortunately.
thought I was out, they pulled me back in.
Yeah.
It's
Hey,
like,
Bob. So
yeah,
I've been wanting to ask you this all day, especially as defense
Me too.
attorney, and I think a lot of people will really want to know your view on this. So when you finish a huge trial like this case, most lawyers, I mean, we like fall back, and I have to like sleep for a week to sleep it off. It's
we,
exhausting.
yes,
What happened in this case was they tried to talk the defense attorneys tried to talk to the jurors. They were stonewalled, but then to follow up really 6 months later and to do a lot of investigative work. I would love your thoughts on two things that I think a lot of people would love to know. Is this normal? Do defense attorneys or any attorneys kind of go I've seen some people say go hunt down jurors and try to get them to talk. Is there something wrong with doing that? And number two, is there anything wrong with them going to their houses and getting these affidavits? Are they allowed to get these affidavits from these people who just maybe wanted to shut their doors and, let this whole big fiasco put to bed and not be a part of it? So I'd love to hear your thoughts as a defense attorney and what you did when you had big cases.
yeah, it's a great question, and frankly, just because of the nature of the business, we're typically on the losing side, right? I mean, like obviously, Allison and I are both pretty good attorneys, so we won our fair share of cases, but we lost our fair share as well. Some cases you just can't beat the facts, right? So in those cases, if we felt that there was a irregularity that would maybe have been going on with the jury, or that we thought that something may have happened with respect to way the state may have handled something with respect. Like we had a case where the in-court identification, like the juror, like for the witness, just for whatever reason, could not pick out the defendant from me sitting next to the defendant. So the prosecutor then came over and stood next to our table and like put his arm out and he says, "Okay, do you see anyone at this table?" Like literally pointing at the defendant that you think would be the defendant. And then the witness is like, "Oh yeah, it's the guy in the green shirt." So it was like, and then there were a few other things. So and we always want to know. I mean, just from a practical standpoint, I want to know what worked for them and what didn't, what turned the case for them. Like just for my own edification, I always want to know what turned it for them, just so I can learn from it and move on, So yeah, I mean, there's been many occasions where we've tried to track down jurors. I've run into jurors on cases at the grocery store when I'm like shopping for food, and I'm like, "Oh man, like I've been dying to talk to you. Would you talk to me for a couple of seconds?" And most of the time they're typically pretty affable, and they'll talk to me, and I'll be able to get some information. In a case like this, like you said, it's hard to explain to people that don't practice law and try cases just how exhausting it is mentally, because like you want to talk about real tunnel vision. In terms of trying a case, you are oblivious to everything else that's going on in your life, including your family, like every other case that you have on your plate. It all falls to the wayside, and you're just so, I love you, sweet dreams. You're just absolutely focused on it, and it's like a constant battle. It's like if I'm preparing for your case in chief, and we're not playing nice in the sense that you're saying, "Okay, here's our witness list, this is the order we're going to call in," and you've got 50 to 60 witnesses, and you're leaving it up in the air, which you frankly have no obligation to give us that information. It's not like a rule, at least where we practice, that says, "Okay, play nice, tell them who you're going to call, we want to try to move this thing along." So
We
like,
tell you the witnesses.
yeah, so like there's this element of guessing. So like when it ends, you do want to decompress. You just want to, like, the last thing that I ever want to do is go knocking on jurors' doors. But if I feel that there might be something there that's worth looking into, but like in Illinois, we have 30 days before the court loses jurisdiction in order to get a motion for a new trial on file. So like, because when I hadn't looked up what the statute was in South Carolina, but like when Alice and I were looking at it, I'm like, wait, like, didn't they lose jurisdiction? Like, what is this? And I didn't realize what the basis of the motion was. And then, of course, I looked up 29B and I'm like, oh, well, they have a year basically, as long as they show they exercise due diligence in terms of, digging out the problem. And then I, of course, looked up when she published the book, because that seemed to be the impetus for them to go like, say, all right, something stinks here. So, yeah. And I've knocked on jurors' doors. Some are receptive. Some are like, I've never had somebody slam the door. Like I always come in cordially. I'm not coming in aggressively. I'm like, oh, we'd love to ask you some questions if you'd be willing to talk to us. And they're like, no, thank you. Like I've moved on, and I walk away, and I've had jurors that have talked to us for hours. The Garcia case, I mean, I wanted to talk to all those jurors, because I just felt like in terms of what the evidence was, that they went against the manifest weight of the evidence, that's just how I felt. And I wanted to hear for them, was it the fact that my client slept through the trial? Was that like a big issue for you? It's like a death penalty case and this guy's sleeping. Did it didn't matter what I said? So yeah, those types of things. So yeah, and in this case, it's like Newman had made a statement that, at the end, he's like, look, you don't have to talk to anybody. And I don't want anybody to approach, the jurors at all. It's completely up to them if they want to come out and talk. If they want to do the talk show circuit, that's up to them. But, but I don't know that applied to the attorneys. I think it's fair game. Within reason. Obviously, you're not stalking people, but I mean, we can learn a lot from the jurors. And the same goes, like, if you guys get an adverse verdict, I'm sure you're like, man, where did we miss on this thing? Like, we want to go and talk to them, but it's different. Like when you're a private, if I'm a PD, I'm not doing that. I mean, I just don't have time to do it, because as soon as I'm out of a trial, I'm probably working on the next one. Yeah. So for if you're in private practice, you have a little more leeway in terms of kind of like digging into it after the fact. But yeah, man, like this thing just blows my mind. It's crazy. And there's so much, like, Brett, you nailed it, man. There's just so many fascinating legal issues. I mean, like, I want to ask you guys, can Newman sit on the bench for this thing? No way. No. Right. I mean, not after what he said.
He's in the affidavits, so he's part of
the witness.
I mean, he's a witness in this. He's probably going to be called. I mean, truly, this whole thing is such a mess, because this is a small courthouse as well. Right. And he's implicated in all of this, in that he will know certain things about what he told Rebecca. It's going to be very messy, and he's going to have to testify, I think.
100%.
Yeah, I mean, this is going to be such a mess. I mean, presumably he will handle this up until, he'll handle the evidentiary hearing and make the decision, unless he recuses at that point, which he could do. If it comes to a second trial,
he might have to do, because of what he said. Like, his statement after sentencing, where basically he just flat out came and said, look, based on the circumstantial evidence, the direct evidence, everything you saw and you heard, you made the right choice here. You came to the right verdict. He basically took himself out of play as being unbiased, I think, in the sense that there's no way that he can take that. There's no unringing that bell. I mean, he's in agreement. So I know exactly what his position is.
I don't know that I agree with you on that.
So how do you couch that?
I think, okay, well, there's two things. Number one, the statements I'm more concerned about are the ones in the affidavits and in the evidence, where he talks about how it's concerning to him that the clerk was talking to the jurors. Like, to me, that's more concerning, because that puts him right in the substance of this misconduct. Not that he was engaged in any, but that he becomes sort of a witness to it. I think the fact that he thinks the evidence is overwhelming that Murdaugh is guilty, I don't necessarily think that's bias. I mean, he has to make that finding anyway. At some point, he's going to have to make a harmless error analysis. But that's only one part of it. The fact that the evidence is overwhelming, that's one part of it. That doesn't necessarily mean that the prosecution can overcome the presumed prejudice, the very heavy presumed prejudice in this case. So I don't know that I necessarily think that's a problem. But the other part, where he's involved and he's making statements about her misconduct, that I think, I kind of wonder if maybe he should recuse and have another judge come in. And honestly, it might be better, even if I don't think he has a conflict.
Yeah.
What you just said, the appearance of conflict matters too.
That's what
There may
I'm
be an
saying. Like from
appearance
my
there.
side of it, if I'm Poot and Jim, if he's not recusing himself, I don't even want him sitting on and hearing. Like I don't even want to argue the motion for leave to file it with them. You know what I'm saying? Like I don't want to take that chance. And I hear what you're saying, because you're right.
I think the allegations here are so serious, and it has to do with the actual courthouse, that just for appearance purposes, it would probably be best for everyone involved to not have any question. I tend to side with Brett on that in terms of it, but I think he's in the midst of it, and also for the rest of the world, like there are allegations, very serious allegations of a court employee here. We need to make sure that everything is kind of as clean as possible moving forward.
100%. And plus, I know you guys have real jobs, so you probably weren't on Twitter all day, but I was, of course, in a Twitter war, because there's the faction of people that are like, they've imputed their hatred for Murdaugh, which we all have. I mean, he's as bad as you can get in terms of human beings, but they're not mutually exclusive things in terms of, like, you can hate Murdaugh, but you can still realize that the Sixth Amendment of the Constitution matters, and it trumps Murdaugh and your hatred for him in terms of, did he receive a fair trial? I mean, there are two things that never have to meet. You know what I'm saying? So, like, in terms of him being at Moselle, and when they took the field trip, and people are saying, well, Judge Newman was there. Like, how didn't he see Becky Hill wandering off with jurors and having these deep discussions? And it's exactly what Alice was saying. Like, look, we don't, like, you have to understand, jurors are coming into this as like unmolded pieces of clay. They're unfamiliar with the entire process. Everything is brand new. It was like kind of the basis of my podcast. I realized, 2 years into practice, that my clients, when we'd walk up to the bench, and, we do what we do, and then we walk out of the courtroom, and my client would say, I didn't understand one word of what went on in there. And then it dawned up, because at first, even as attorneys, we don't realize how little that they understand of that process, especially if it's their first time in the process. No matter whether you're a defendant, whether you're a plaintiff in a civil case, any of it, any movement into the judicial system is brand new territory. So those folks don't know. And they might not, because like that whole question of, because we know, like, Egg Lady, that's going to be an issue. Like, Judge, like when the judge ordered her, when he excused the jury and he's directly asking her questions, did you speak to the clerk about this case? And she flat out said no. Now we've got a contradictory affidavit where she's saying yes. Yeah. So she's telling the truth at one of the times, and that's going to certainly be something the state is going to attack massively.
And if it were just her, I wouldn't be that concerned about it.
Exactly.
It's the other ones.
It's the other people. And Bob, I want to highlight
thing.
what you just said, because we've already said it, but it's really helpful when people hear from both sides of the V here. You said there's nothing wrong with Rebecca speaking to those jurors individually. Exactly. They could have been talking about the weather. So the fact that the judge saw, if he saw, we have no idea if he actually saw, but if the judge saw, or Harpootlian, or even the prosecutor saw Rebecca Hill talking to an individual juror, I would not think a single thing of it at all. And I want to note that, because I think it's easy to see such a powerful motion here and all of a sudden think the judge was in on it. Harpootlian sat on it until now. The prosecution must have seen it and they didn't do anything about it because they sided with Rebecca. I want to make sure that we kind of put those things to bed, because I have seen, the bailiff and the clerk of court talk to all the, you know what? I'm not going to the judge and the attorneys will not ask the clerk of the court what they were talking about, because we don't want to even skirt upon knowing more about the jury than we should, because that could look like misconduct on our part to do any of those things. So I think what you said is so important there, and I think people need to understand that and put to bed kind of additional conspiracy theories of other bad actors. I think we are facing one really bad actor potentially. Here.
And I want to jump on this, because I want you to confirm this, because I want everyone to understand. The reason we are so shocked and horrified by this is so outside the norm. Like, the fact that she would do this is such a betrayal. And there are thousands of people in thousands of courts around the country who have this job, who do it, with honor and would never do something like this. this is not sort of a systemic problem.
No.
This was her problem. If she did this, it was, I mean, she basically sold out her position for fame and glory. She wanted to be on the Today Show. She wanted to be in documentaries. She wanted that book. It's shocking and heartbreaking and everything else.
And by the way, maybe I'm just like naive. I think she would have gotten all of those things no matter what. Even if maybe it would not be as sexy if it was a mistrial or acquittal, but this case, as it was going on, we didn't know the verdict. And it was like 24-hour news about this case. I think she could have still made a lot of money, however the outcome was. And I think because the evidence seemed so overwhelming, it was going to be a guilty verdict. But if it were an acquittal, I think Hollywood would have jumped all over it. She could have been there and been like, absolutely, it was overwhelming. This is a miscarriage of justice, whatever, what have you
100%.
about it. She could have made a ton of money, I think. So anyways, I say all that with,
I agree.
We'll see, if these allegations turn out to be true, but we are so horrified because I've never seen this in my career.
You nailed it. It's like, I was asking, I'm like, today in South Carolina, is it the norm for the and we're talking about the county clerk. Like here we have bailiffs. The bailiffs do the judge's bidding. They call the court to order. If there's, jury duty that's going on, they are hand holding the jury. They go down to where the jurors gather in the morning. They bring them up to the separate courtrooms. They go in, they cater them to during the day. What are the lunch orders? This is where we're, all those dynamics that go on with the jury, because we really do treat them as the special individuals they are. They're the sanctity of that room is treated as such. There's a reason that we stand every time they enter the room and every time they leave the room. That matters. It matters. It matters to the decorum of the court. If we lose that, we lose everything. So all those things, and the three of us would never in a million years. I wouldn't even I wouldn't even have sniffed it if I would have seen her talking. I wouldn't have been like, ooh, well, if she told me, I never would have thought it. It never would have entered my head at all.
Even when the judge says, I don't like the fact that she was talking to the jury, Jim's just like, yeah, that was weird. He doesn't demand a mistrial because he also doesn't recognize.
We would never allege something like this because it's such a huge allegation, right?
It doesn't happen. It does not happen. It's just that's what makes it so stunning. It does not happen, especially from somebody in that position. I mean, she's an elected official, and it's mind blowing. It's you said, Alice, getting sucked into that vortex of that case. I mean, in terms of cases, and Brett said it a long time ago, this is it's one of the best cases in forever. We've got those incredibly classic cases that we'll think about in perpetuity. And you had OJ for all the craziness that was, and you had a judge that lost control of a courtroom, and the defense was running the show, and it was insane in an entirely different way. And but it's just one of those cases where the entire world was watching. And I think that she got sucked into that vortex of fame and fortune. And I'm making the appointments with the media, and I'm running the game here, and they're coming to me for the, and it's she just lost sight of it, because I can't think of any other reason, because she knew better. That's the one thing. She knew better. It's her oath. It's her duty. And she broke it, and it's going to cost the taxpayers a ton of money to retry this thing. For everything that Alice was saying about, look, the defense has the playbook, so does the state, but you know what? It's not about that. State has the burden. It's a much bigger advantage for the defense. And I just got off a live with Dr. Kinsey, and he's like, I don't even know if I would do it unless Creighton sits down with me and basically, appeases me to what, because he's like, I have other clients, I have other stuff to do. I don't know if I'm willing to do it. You know what I mean? So they're not necessarily going to have all the same witnesses. It changes the dynamic. Plus Griffin's getting a second chance at not opening the door on the roadside shooting. Maybe some of the financial stuff where he'd kind of cut it off a little bit, where Griffin made another mistake, opened the door to that, the floodgates open. They're not going to make those mistakes. Like you said, if Murdaugh's an idiot, he's not testifying, but I think he's such a narcissist and such a egomaniac that he's not. His mindset's going to be, oh, well, I know I could do better. I know I can convince them. That was all you just made. I just got to change a couple. Like that's his mindset. So,
But he gets a do-over too, even if he does testify.
totally.
He can learn from his mistakes.
Yeah. He's
Like
not going to walk into
they
those
will
same
test
issues.
they will like crowd test that crap, and I bet you people will be like, I didn't like how you called him Paw, and he'll probably change. You know what I mean? Like he can
100%.
actually test all of these things and see what comes off good and what comes
He'll
off
change
bad.
his story about the badge.
Right.
You know, they slammed on the badge. He'll change his story about the first time he lied about being down there.
That's
because
the
they
thing
slammed
with,
him on that. I mean,
you and I had that discussion months and months ago, like while the trial was going on, and we both like he just took the wrong approach with that. He had to have owned it and said, look, I did lie about it, but I lied about it because I knew that you guys were looking at me as the guy. So
Right.
like I wasn't going to put myself in a position where it made me even more the guy in your eyes. And it was that simple. There was nothing nefarious about it. I just wasn't like willing to put myself in that position because I obviously didn't know that my son had taken a video that was going to blow up my entire world and create a timeline in which that, like they were able to establish the time of death. It's like that whole aspect of it is crazy, but man, there's just so much like when I see something like this, it automatically makes me think that she's done it before. Like she was so casual about it. Like it automatically makes me think, man, is it possible that she's done it before? Even if it's just like, I'm just, casually talking about the case. It's like, I don't consider it to be material to the case. I'm not telling him which way to vote, but like it's potentially going to be a nightmare scenario because I'm telling you, if I had a client that had a trial with her as the clerk, I'm looking into it.
I'd be talking to every juror.
And Bob, that's a great point because I think all the things that you said that this is going to cost taxpayer dollars, it's going to by the way, all the witnesses who have like vicarious trauma, real trauma from testifying, I think the biggest blow to all of this is on the judiciary system, right? The fact that we are also outraged is a good thing because I think it shows that this doesn't happen. But you betcha everyone else out there who may not be in a courtroom very often, they're going to question every conviction. They're going to basically say someone in that courtroom is trying to do something to sway the jury, and that is a huge hit on the judicial system. That's a huge hit on our justice system because guess what? Actually, the jury system is a fantastic protection for anyone accused of a crime.
Yeah.
I mean, it is thank goodness we have the jury system and it's not just up to one judge.
Can you imagine?
Yeah.
I mean, as flawed as it is, it's the most beautiful system on the planet. Like there's no better legal system than ours. The Constitution's my Bible, I mean, it really is. It's like, it's everything to us as a society. So to me, you guys know how crazy I am about the Constitution, but it matters. It has weight. It's the foundation. It's the bedrock of our society. It's how we started this country. That document is beautiful and it's breathing and it's alive and it's fluid and it changes. And it's everything that we base our entire legal system on and really our society. So it's like, we have to protect it at all costs.
And I just want to say to the people in the chat, there are affidavits from jurors who voted to convict this man saying that she did these things. Right. Maybe she didn't. That will be decided later on. There will be an evidentiary hearing. But just because we all liked Miss Becky back in the day doesn't mean that we should assume some sort of like halo over her. She wrote a book that she was writing during the trial. She is now being accused of doing these things with affidavits, sworn affidavits under penalty of perjury about things she said and things she did. These are serious allegations. They need to be taken seriously. Absolutely, there needs to be a hearing about this with testimony, and we need to make sure that it actually happened. It may very well be the case that at the end of that hearing, we'll decide all of these affidavits are wrong and she didn't do this. But if you're sitting there thinking this is like, well, why should we believe this? It's just Pootie Poot and Jim. No, guys, this is really serious. It's far more serious than any motion for a new trial I have ever seen.
Me too, man. Me too.
Never seen anything like this. Never seen anything
like this. Dude. I was stunned. All right. So Robert Palmer asked an awesome question that I definitely wanted to ask you guys. And what do we deal with? What is the scenario if Becky Hill decides to take the fifth? Because I mean, like,
That's a great question. Because
I
she
mean,
should.
man, it's like, think about that. Like if she decides to assert her Fifth Amendment right at that point, I mean, it's basically an admission that she's not willing to. I don't know. It's like the whole scenario is so crazy.
Well, that's
Well,
actually
in that
really
case-
interesting.
oh.
You can only plead the fifth if there is a possibility of criminal,
Which
right?
there
Am I right
is.
about has to be
There is absolutely a possibility of
no,
criminal prosecution
no.
here.
I know that. But if this is interesting because there are also there's potential civil charges that can be brought. So it would be interesting whether, we've seen situations where the prosecution will come out and say, like, we will not prosecute you based on this, so you can't assert the fifth.
Right.
I'm not sure that this is the situation in which they would do it. I only note that because it has, in a blue moon, happened before. It doesn't absolve her of everything, but she can only assert it if she could be
If I'm the
prosecuted.
prosecution, I want her to go to prison.
That's fair.
So
That
I
is
would
fair.
not be giving her
That's
a
why
new-
I only note it because it is a possibility. It is a chess piece that can be played.
Oh man, it's such a crazy scenario though. It's like, because for all intents and purposes, if she takes it, if she pleads the fifth, that she, like, you have to assume that what she said in terms of at least what was alleged in the affidavits was true. I mean, you can't
Well,
take
look,
it any other way, right?
If the jurors get on the
Well-
stand and say that she said these things and did these things, if they say that under oath, subject to cross-examination, and then
Right.
she takes the fifth,
That's it.
absolutely.
Yes.
I think
yes,
you-
because then you
you-
have to weigh the evidence of what you have,
Exactly.
and we do
Of
have
course.
her words in some of the transcripts, and so we have her words in the book. That's fair
Yep.
game as well. So I think if those jurors are cross-examined, then this is the evidence that you have. You have to weigh the evidence before you. We say this in jury trials all the time. They can only weigh the evidence that's presented to them, and if
Yep.
what's presented to them is cross-examined
That's
testimony of the jurors and plead the fifth,
That's
there's
what
the
you got.
evidence.
That's what you got. Yeah. So it's like it's a never ending just cycle of like craziness with this case. It's like we could talk about this for 10 hours, like literally, because it's just like the whole thing is so fascinating. And now it's moved into like the horrifying territory, because it's like, I mean, if you're the state, are you weighing the concept of like, and I don't know what he's potentially looking at from the Fed side of it on the financials, but I'm assuming it's going to be a hefty amount of time considering what his age is. Theoretically, could he be doing life on that? Do you, like, if you're sitting in South Carolina and you guys are in the war room and you're like, all right, let's assume the worst here. Let's assume that he's going to be ordered to have a retrial. Is there a concept where you're saying, let's not even do it? Like the Fed, because like, I know that there's that argument out there that like, the maneuvering that's been going on is in order to get him into a federal facility. I mean, like, does anybody really care what facilities like, it's moderately nicer, I guess. It's still, prison is prison to me. Like if you're in a cage, you're in a cage. It depends on the federal joint, man.
So if he gets a new trial, then I think you're right. The federal cases will be resolved beforehand, and we'll know what he's going to get.
Yeah,
and I think he will get significant time based on what his co-conspirators got. He's going to get the most.
Right.
He, like you said, given his age, that may be a life sentence. I think you got to try it again, though. I don't know that you cannot.
I think you'd have to try because those are the financial crimes, and we have victims here. I mean, not that you don't have victims with the financial crimes, but you have two people who've lost their lives here.
No.
Now, it may make a difference for him. If I were Murdaugh, I would not. I know a lot of people have said, "Oh, he'll just take a plea deal." If I were him, heck no, I'm going to trial. I have the playbook and I am going to win. Like he has a much better chance the second time around. Having had a dry run, essentially, you have all of the secrets of the prosecution. And I don't actually mean secrets. I mean their entire playbook, their exact questioning. You know this, Bob, from doing trial. You
100%.
have literal outlines that you're going to dig out again, and you're going to ask the same type of questions because you have to meet the same elements. So he literally knows what questions will be asked of all of the witnesses the second time around. No way, if I'm Murdaugh, am I going to take
the best comparison is like when you freshman year in college and you joined a fraternity or sorority and they had the cabinet that had all the tests from all the professors for all the first year and second year classes. And like, you know, they had the collection, and you're going in and you're able to review all that. And if you have the professors that never change, like I had a law, like my outline that I got for like 3 or 4 classes with the same professor in law school, the guy never changed one word, like down to the jokes that he gave. Like the person who like did the outline that gave it to me, like was like the exact same outline. The guy never changed one iota of his dialogue for the entire semester. So like having that is such a huge advantage because you know how to prepare for it ahead of time. It's like, I think you said from Murdaugh's perspective, yes, 100%. There's no way he's pleading. Like there's no carrot. It's like the same argument, like, you know, like in a death penalty case, if they're going to take it off the table, or if it doesn't exist, you don't have that carrot to offer. You have no reason not to go to trial. You know
And
what I mean?
also remember, I mean, we've talked a lot about this when we were covering the trial. There is a very real difference between being someone who's been convicted of like financial crimes and a murder of your own child.
Oh, no
Those
question.
are those, I mean, and this matters to
No question.
everybody.
In
Absolutely.
the joint, especially, it matters.
Sure.
You know,
That's
your
a
life
really
is,
good point.
yeah,
Hey,
your
Bob.
life is way worse if you're a child killer in prison than if you like you're a white collar guy like that. It's night and day in terms of like you're under constant. You're doing this all the time. If you killed a kid in prison, you know, it's always looking over your shoulder.
So here, I have a question for you, Bob. Second trial happens. Murdaugh decides not to testify. He's now asserted his right not to testify. He's now an unavailable witness, which means that his prior testimony taken under subject to cross-examination there's a hearsay exception to that. Can you enter his prior testimony into the record in his second trial against him?
Man, I think that you can, you know, but it's such an interesting legal argument, though. You know, it's like, because I was actually researching that exact issue today because like I didn't flat out know the answer because I'd seen a couple people say, oh yeah, you know, if he decides not to testify, they're going to be able to get his sworn testimony in because he's an unavailable witness. But the question is he truly unavailable? You know what I mean? It's like that, like to me, that's what the balancing act is going to be if he's refusing, which is his absolute right not to testify against himself potentially. You know, but it's such a fascinating, like, what do you guys think? I think that there's a good chance that they're getting it in.
I mean, it's
Well,
also a
it's an
prior
interesting-
statement of an opposing party. And
Right.
Right.
but
I don't
we-
know though, because then you have to test the bounds of how you can plead the fifth. It's not pleading
Right.
the fifth if you can allow the previous testimony to come in. But if he had said someone to someone else, that's a party opponent statement that does come in, and Fifth Amendment rights aren't implicated. So I think
Well,
it's
what
an
happens if
interesting question.
he doesn't even assert his fifth? He just chooses
He
not
just
to
doesn't
testify.
testify.
You know what I'm saying? Take the fifth out of it. Just like if he decides, well, I'm not going to testify because they're concerned. But like, I mean, there's going to be a motion to eliminate about that.
Oh,
so
yeah.
they're going to know going into it, and they're going to figure out whether or not that's coming in. And if it's coming in, he's definitely testifying. You know what I mean? So it's
Right.
like he's going to have to.
But
like,
then
you
if he
know,
testifies, you can use his
impeach
prior
the hell out of him.
testimony to impeach him.
I know. It's like he's going to have to. He's going to have.
It's going to be an
suck
interest.
up
It's
on
going to be
himself.
wild. It's going to be
crazy.
It's going to be wild.
It's
Let me
just-
ask you
it's
this
just-
too, Bob.
It's an unbelievable case. It's just so
Look.
crazy.
It's possible we'll have this evidentiary hearing. These allegations will not be substantiated. Becky will be suing Harpootlian for defamation.
Libel,
We can watch
slander,
that trial.
all of it.
Exactly.
Yeah.
But assuming that doesn't happen, assuming allegations are substantiated, do you think it's pretty much automatic we will have a new trial, or do you think there's any chance that the sort of high standard for harmless error in this case could be met by the prosecution?
I think, like, and this is what my gut is, and it's based on everything that we've been saying tonight. I just can't see a world in where these witnesses came forward, these former jurors, and are making it up. You know, like, and if I'm taking it at face value and looking at, is it possible or more likely than not that he did not receive a fair trial based on what she did? Like, to err on the side of caution, he's getting a new trial. I mean, like, we can't mess with the sanctity of the system. We just can't. We can't take that risk. It's not worth it. So I think that ultimately, at the end of the day, I think that it's, if even if she testifies, even if she says, okay, I didn't say that stuff, they're blowing out of proportion. I don't know where they're getting it. I don't know how they're all saying the same thing. You know, when I was in the bathroom with this person, you know, we were talking about what we're going to order for lunch. It had nothing to do with the trial. And she goes on and, you know, basically comes out with what she feels are valid excuses as to every conversation. Those were offhand comments that I made. I certainly wasn't trying to guide the jury and say, look, I was just saying, you know, keep your minds open, you know, focus on the things, focus on everything. It's very important to watch every single movement that a witness makes because we're trying to judge.
Which, by the way, you still can't do.
Yeah.
Which, just by the way,
say any of
anyone
it.
listening, Bob is such a good lawyer. He might be. Just know that you can't even do that.
Can't say
No.
any of it. You like it's Alice, you were talking about it. It's like that speech that they give us, you know, please don't, like, if you see a juror, you see one of the participants in the trial in the hallway and they just do this when they're walking by. It's not because they don't want to be your friend or they're rude or they don't like you. They cannot speak to you under. If I see somebody in an elevator that's a juror in a case, I'm waiting for the next elevator.
Oh,
if
yeah.
I see somebody in a lunchroom, I'm leaving the lunchroom because I can't risk ever having even an ounce of impropriety in any way, shape, or form. They're even in the same room, like, oh, you know, did you slip them a note? You know, it's like you avoid it like the plague. Yeah.
Alice had
let
a
me push
witness hug a juror once.
Okay. Oh, I couldn't control. I mean, it was an open court. Like it was. I had nothing to do with it. The judge was like, "Whoa, keep moving." But
They love that guy so much.
they really did love that guy. But Bob, let me test what you said just a little bit because I think it's two different things, right? Like we talked about that if there is an evidentiary hearing, there's going to be first whether these affidavits hold up. Let's assume that they did. And I agree with you there that I don't think these are made up whole cloth. It might be something more innocuous like, well, I didn't hear it firsthand. I heard it from someone else. And I actually didn't hear it either. After the fact, we were talking about what we remembered and that person said they remembered. So I agree with you. I don't think it's made up whole cloth right now, but it may not stand up to cross-examination. That's not what I find interesting because I think there's going to be a very good likelihood that with all of these similar comments from different affiants, something's going to come out. What I find more interesting, and this is going to bring in your experience from court and also from voir dire, is the jurors have to be able, the jurors who have sworn testimony here have to also say, but for what she said, I would have voted a different way. And I say this because you and I both know when there's voir dire, people say crazy things that could get them disqualified from the jury, right? They say things like, I can't believe any law enforcement officer. If they wear a badge or a uniform, I don't believe them. And then what does the judge do? The judge tries to cure it, right? They ask questions to see, well, I understand you don't like law enforcement officers. Can you put that aside for this case and listen to my instructions and give the same weight to all of the testimony you hear? And almost always people are curable because people like to be agreeable and they don't want to be that person who is like, giving the wrong answer because there's a right answer to that question, right?
Exactly.
And so oftentimes we are able to cure a juror before they're sat,
Much
but
to
we're
my
like,
chagrin.
whoa, I still don't want them. I want to strike
Much
them.
to my chagrin.
Right, much to your chagrin, but
Yeah.
that's why we get strikes, right? And that's oftentimes why the attorneys say, okay, this person's technically been cured. They said they can follow instructions, but what they told me ahead of time about all their biases, they're not going to be good for my client or for the government. So I'm going to strike them, not for cause, just because I don't want this person on my jury. There's going to be that same sort of analysis here. And knowing how we see jurors often get cured, do you think that these, particular affiants being questioned about whether they really would have changed their mind given the weight of the evidence? Because the prosecution is going to come in and say, really? You would have changed your mind even though you saw this video and you saw this and you saw this and you saw, it's going to be a lot that they're going to have to say, I would have, I would have said not guilty. It's going to feel like a lot of questioning, and it is a pretty high bar that the prosecution has to meet here. Do you think in that instance, what's your prediction here?
I think the bar's lowered because of her office, to be honest with you. I think if it was anybody else that what you're talking about factors in terms of the judge making a ruling on it, when you look at it, because like the way that I was trying to explain it today is like the human mind is just so fascinating and we know so little about it. 6 months post verdict, you're sitting there and you're trying to go back to sitting in that room on that day when you're deliberating and trying to figure out the impact of what she said and trying to truly understand whether or not it impacted you in a way, if you were on the fence, that it tipped you over towards guilty is so impossible to really come to that conclusion, because like our minds are just so fragile in terms of like that. Like, how do you pinpoint that? Like, how are you able to actually say, okay, I could say with great certainty, had she not said that, I would have voted not guilty. You know, it's like because that situation didn't actually exist. Like, how can you say that unless you're in the situation with the the attenuated pressure of the situation? You know, it's like you can't. It's like practice in games. Like, you can practice and practice and practice all you want, but there is no replicating game time experience, right? And it's like kind of the same concept in terms of a jury, and like for like that amount of pressure that they feel when they're in that room and they have the weight of the world. It's like we're always so like thankful to jurors, because that is an incredible ask from us as the attorneys in the court, you know, to say, hey, we're asking you to sit in judgment as somebody that could potentially end their life, or it can put them in prison for the rest of their life, or for any portion of their life. It's a huge thing to sit in judgment and make those judgments, knowing what the result of your decision is going to be at the end of the day with respect to that person. So it's like, I don't know, like if I'm the judge on it, I'm tortured by it. But at the end of the day, if I feel like I'm taking that concept into consideration and I'm saying, look, I'm going to err on the side of caution here, because I just don't know that without all the circumstances being put into place that the person can actually answer it like truthfully or honestly, because they just don't know the answer. Not because they're trying to be evasive, but because it's really, really hard to give an accurate answer as to what you may have done, because the other circumstance never existed for you to know. You know what I'm saying? I mean, it's such a hard thing to figure out. I don't know. Like, I don't know how, like, I think ultimately if it's a close call like that, if it comes out that the judge buys what they're selling in terms of these affidavits, I think it's you know, he's getting a new trial. I think that's the way it's going to go down.
Like, I don't trust Egg Lady. But when you read her affidavit, like, if it's true that she told her everything Mr. Murdaugh has said has been lies and that I should forget about the guns, they'll never be seen again. I mean, and I'm with you, and I hate it, because I think this guy is guilty of sin, and we did 10 really good episodes on this case, and our 10th episode was amazing.
I don't think we can redo it.
We're just going to release the episodes again as if they're new.
Exactly.
You know what, Brett? We have the playbook of the prosecution.
There you go. There you go.
There you go.
I mean,
I'm with you, man. I'm with
if
you,
it is,
lady.
if it's proven,
and she's contradicted herself, and that's the other thing.
I don't know about Egg Lady.
Guys, look,
this doesn't rest on Egg Lady. Thank you.
It does. It's cumulative for sure. I mean, it's the totality of the circumstances and the totality of all the statements are what the issue is going to be. But how are they going to address? Because people are going to be looking at the jurors as well. Because Newman asked, like all judges do, every day as soon as they walked into court,
has anybody
talked to anybody about the case?
Yep.
Like, anybody talk to you about the case? No. And for the entirety of the trial, every single one of them said no. And like the only answer could be, again, they didn't know that it was necessarily her doing something wrong.
That's the thing. It goes back to who it was.
Right.
That's why it's so pernicious.
She has authority. She is the court. They didn't talk to anyone because they're currently talking to the judge, and they don't really know the difference between the different court members. Exactly. They are all cloaked with the authority of the court.
That's what makes it so infuriating, because of her.
So
position.
Infuriating.
Man, it's the worst. It's just the absolute worst.
Wow, I've missed you. It's really good to have you back. Yeah. You know what? The only good thing, if we have to cover a new trial, is we'll get to talk to you a lot more, because we had a lot of fun.
Here's the thing. If there's a new trial, every night we're just going to get on and talk about the trial.
Oh, totally. And I finally
just do it every night.
I'm a patron of the.
Oh, wow.
Okay. So yeah, well, I was dying to hear 13 and 14. I'm like, I can't wait. I'm not really.
Oh, you're the
So
best,
I'm
Bob.
like, plus I love y'all. So, and I always
You're
want to
the
support
best.
the
We love
show.
you too.
So yeah, and I thought you guys did an amazing job on that. And I was out there fists up.
You were,
fighting
as I said, you were like a hate sponge. You were taking all the hate for us.
You
It
know,
was great.
hate sponge is true, man. Thanks for
Oh
that.
man, you know, it's like I just thought you guys did a wonderful job with it. I thought
Wow.
it was what you guys do, what we do. You know, there's no one in the game that does it better than us in terms of giving all the facts, giving a completely objective. Yeah, I mean, I just like it, no matter which way. I never felt that you guys came in with a preconceived notion, you know, because like when you do come in, like, yeah, you might be feeling, yeah, you know, I think he's kind of guilty. Like it's always kind of run through my, but when you go through the process of going through everything that you guys did in that way, you can't help but reanalyze it, you know, and that's what people don't understand. And I understand it because it's what we do for a living. Like that is what we do for a living. Like you guys tried the damn case, and I thought it was beautiful. And like, you know, I applaud you guys. It was great. We're doing the same thing. And Brett, like the Avery's coming out, and it's going to be pretty intense. So
I'm
y'all,
looking forward to
like,
it.
I
Yeah,
want
me
you
too.
guys, I want you guys to like, and I'd love to talk about that because it's like, to me, they're hand in hand. They're vastly different. But like originally, I just wanted to kind of go through and do, you know, I wanted to handle Zellner's PCRA stuff. Like, I'm like, all right, I want to see if these things have legs. So, but of course, as soon as I start digging into the evidence, I realize immediately there's no way. Like, I've got to dig into the
Gotta
case.
go all the way.
Allison, I'm like, this went from 6 to probably 20 episodes.
Awesome.
So much. There's just so much there. And I'm coming in completely objective because it's like I said, I can't, as much as I love you guys, as much as I love anybody. And like, I trust, aside from myself, I trust no one more in terms of like coverage of case than you two. Like, that's it. Like it's me. But like for me, much like you guys, like I need to look at the evidence and evaluate it on my own. I just have to. It's the only way that I can come to my own conclusion. So I just realized that, man, I got to look at it all. I got to do it all. So we're going to do all the police reports. We're going to do like, and there's no agenda. Like I'm not coming in. Like I think I've misnamed the series. It's like making the case for Avery's innocence, but I
assumed you were going to say he was innocent.
That's what I
based
thought.
on the name
so
of the
I
series.
explained in the third episode. I'm like I want to be clear. I'm entirely on the fence on this. I am not. Like I can see a world absolutely where he's guilty, and I can see a world where absolutely where he's innocent. At this point, I don't know because I've never dug into the evidence, and there's no way in the world I would ever go by what Making a Murderer put out there because it was cherry picked and they had an agenda. You know, like that. For as much as I loved it at first blush, as soon as it was over, I'm like Googling, okay, well, there had to be more because there's no way they got a guilty verdict on that. What did they leave out intentionally to make it, you know, frame him as an innocent guy? So then, of course, I see that there was substantial evidence that they kept out of that documentary. So to me, that put it as, you know, fodder. You know what I
Bob,
mean?
last night we talked to the guy who did the Convicting a Murderer documentary that's coming out this Friday.
Tomorrow, right? I think
Tomorrow, that's right. Or third
Friday the 8th.
Friday. And he was making a lot of the same points about how that, you know, that documentary was so well done and was so convincing. I watched it, you know, I was into it. I watched every single episode. Everybody was into it.
One day.
Yeah.
But there was a lot missing out. So
huge.
So I guess watch that documentary if you're listening.
Yeah.
You'll get a preview of what Bob Motta is going to do in his 20-part series on Stephen Avery. So
I'm getting like it's going to be every ounce of evidence that existed. We're going to cover the pretrial motions. We're going to see what was left out. And I'm going to account for it. You know, I'm going to say, look, it wasn't allowed at trial, but it existed in the world. I mean, the fact that they had that Denny hearing and they denied the defense the ability to be able to, you know, bring in a potential alternate suspect was huge because it pushed the defense into the position of saying the cops did it all, which is never a defense that I want to go at. You know, I mean, it's like the worst defense because you're getting the judge to say, well, you better tread carefully if you're going to sit here. It's like there's a pat like response that both the prosecution and the state are going to say, like, if you're going to challenge the integrity of law enforcement, you better have something of substance because you can't come with some heavy duty junk because I mean, we've had it happen to us where we've challenged law enforcement saying, I don't know if it's a mistake or I don't know if it's intentional, but I can tell you they got it wrong. And like the judge will ream us a new one. And we're at the end of the day, he's like, when we prove it up, he's like, all right, well, you're a credit to the profession. But we're taking the beating initially. And like, because you're like, we're going to report you to the ARDC if you're coming with a bunch of crap. And, like, we're like, all right, man, like, we think we've got it, like you're scaring us, but we've got to try the case. So, yeah, it's one of those things where we're going to lay it out there, man. It'll probably, like, knowing me, cause I'm not good at editing, it's probably going to be like,
and I also want to point out, if you're coming to CrimeCon, we're doing a meetup at 8:00 in the lobby bar. Bob's going to be there.
Yep.
So make sure, come hang out with us. We're looking forward to seeing all you guys.
That's right. And
Yeah,
real
Definitely
quick,
be there.
let me talk business for just a second. Brett, do you want to, we have to do a sign off, but also do you want to do a sign on, sign off, do an extra episode with Bob?
Since we talked for 2 hours.
Yeah, do you want to do that? So let me sign off. Yeah, there you go. I'll sign off as if it were just us before Bob, and then we'll do another sign on for Bob. Is that okay?
That sounds perfect.
Okay. Brett, I'm not even going to do that. Well, thanks for joining us for this really, really interesting discussion. There's going to be a lot more to come, and we hope you will join us for it. Until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Now, Bob.
Howdy. All right. I love you all. You guys.
Oh, no. I'm really going to have to do a sign on with you. I really do have to do that. Okay. Okay, now I have to think of a descriptor for you.
Now you got another descriptor.
Okay.
Third wheel.
Third wheel. That's pretty good. Okay. It's about time I did something like that after you called me homely. All right. Here you go. Come on, hold it together, guys. Hold it together.
Never.
Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my third wheel co-host, Brett.
No, Alice. Right in the heart. Just hitting me right here.
Brett, before,
not even in the back, just right in the heart.
Before you get too dramatic, let me say why. You're a third wheel in the best sense of the word, because we are joined right now with our favorite defense attorney, Bob Murdaugh, to talk about the Murdaugh filing.
Hey,
favorite defense attorney.
Joining us.
My
low
favorite
bar
prosecutors in the whole world. I'm so happy to be with y'all. I'm excited. I'm blown away by this. So let's dig in.
Awesome.
Oh, that was so good, Bob.
That was so good, Bob. It was like we hadn't been talking for an hour.
Right,
okay,
exactly.
Let me sign off, and you get to sign off too, Bob. Okay. Well, thank you guys for joining us for another wonderful discussion. We always love it when Bob comes on our show. We love having debates with you, and in this case, just hearing your perspective, Bob. But until next time, I'm Alice.
And I'm Brett.
And I'm Bob. Love you guys.
And this is the Prosecutor's Legal Briefs.
Perfect.
Thanks,
Awesome.
Bob. Thanks for taking.
Love you guys.
Like
I'm
second
super
live of the
excited
night.
to get to CrimeCon. I can't wait to hang out and pick a steak spot because we're going. There's no stopping.
I don't know. Let's see.
I don't think you can afford Brett's steak habit.
Let's see what the state's response is at this point.
Yeah, I'm thinking like Sizzler. Do those still exist?
There you go.
Ooh, I like that.
Ponderosa.
Yeah.
Ponderosa.
You know, I'm a big fan of the Texas Roadhouse.
Yeah. Grizzly.
Oh, I love it. I love it.
All right.
Well, this has been awesome,
Thanks
everybody.
for coming on.
My pleasure.
Thanks,
Thanks for
Bob.
having me.
Thanks to everybody in the chat. I hope you
everybody.
guys enjoyed this. I hope it at least gave you a little bit of understanding what's going on. It's wild. It's totally wild.
It's crazy. And we love
This
you
case,
guys
man.
so much.
This case.
All of you guys are amazing. And we love you guys so much because I think we can agree we got the best fans in the world. No doubt.
Absolutely.
Totally.
100%.
None. Bar none. All right, y'all. Sweet dreams.
All right. See you
Bye,
later.
guys.
Bye.
Bye.